unfortunately, there is no bright line test as to what is abuse, what is harassment, what is threatening. Defamation's a little clearer, but the cases turn on specific facts. For example, and I'll use myself as an example, I have been alleged as being corrupt. That's imputation of a crime. I have been alleged to have committed illegal acts intentionally and with malice. That's imputation of a crime. I have been alleged to be unethical. That is not a crime, but it is clearly an illegal act that has the equivalent of criminal penalties. That clearly not only is defamation, and if it's spoken, it's slander. If it's written, it's libel. If it's recorded, as our meetings are, it is libel. But not only that, it is libel or slander per se, which means all one has to prove is that the statements were made, that they are in fact false or overstated, hyperbole. You don't even have to prove actual monetary damages. So defamation's a little bit easier. All one can say is whether it offends normal sensibilities. Talking about, let's say, the police chief's handling of a particular matter, or anyone else's, your handling of a particular matter, as Diane and several others have indicated, that can be done civilly and still convey the same concerns and information that the speaker wants to convey. Case law has held that restraints on those types of comments, abuse, harassment, et cetera, that is not considered content. It's content neutral, because a limitation on those abuses do not address the substance of the comment. If you have a concern about police using swear words or calling people names, foul names, vicious attacks, that's not content. That can be regulated. They still can talk about the police or the legal division or the city council or anyone else they want to talk about public input. They certainly can provide and convey the information about which they're concerned about, their viewpoints, their ideologies, their suggestions for how to solve problems and all. Those other forms of communication deal with tenor. And the cases are pretty clear that kind of content, those types of regulations, prior restraint regulations on speech, are within the First Amendment, even under some pretty strict scrutiny standards. There are multiple levels of scrutiny that I'm not going to get into because you really get into the weeds. But as I've indicated, those types of regulations are clearly within First Amendment bounds, as long as they don't control the subject matter